Analysis. 1. Heading. Bragg has sufficiently alleged Article 3 standing. A threshold issue in this matter is whether Bragg has standing to maintain this action, since the challenge subpoena is not addressed to Bragg or his office. The subpoena was issued to Pomerantz, not to Bragg. Pomerantz has not filed suit. Although he is named as a defendant, Pomerantz asks this court to grant Bragg's motion. Bragg, as the party invoking federal jurisdiction, bears the burden of establishing standing. The Supreme Court has established that the irreducible constitutional minimum of standing consists of 3 elements. The plaintiff must have 1. Suffered an injury in fact, 2. That is fairly traceable to the challenged conduct of the defendant, and 3. That is likely to be redressed by a favorable judicial decision. Where a plaintiff seeks to enjoin a subpoena issued to a third party and has no alternative means to vindicate his rights, a plaintiff satisfies his burden of establishing standing. Bragg's stated interest in the subpoena is his claim that permitting Pomerantz to appear will undermine the pending criminal case against President Trump, intrude on the grand jury proceedings, and violate grand jury secrecy laws, among other things. These assertions are all without merit. Since Pomerantz was not at the District Attorney of New York when the grand jury indicted President Trump, and therefore has no information on that subject, the only arguably valid interest Bragg has is in maintaining the confidentiality of deliberations within the office he now leads. Determining whether Bragg has any alternative means to vindicate his rights is made difficult here, where the court cannot predict what questions will be asked or whether any rights of Bragg will be implicated. In that vein, defendants contend that Bragg has no standing whatsoever to stop Pomerantz from appearing before the committee to answer questions that do not involve purportedly privileged material in either way. The court concludes that Bragg sufficiently alleges standing. Jordan's letter to Pomerantz references the New York County District Attorney's unprecedented prosecutorial conduct and Pomerantz's unique role as a special assistant district attorney. These areas of inquiry at least arguably implicate Bragg's interests. Because general factual allegations of injury resulting from the defendant's conduct may suffice at the pleading stage, the court concludes that Bragg has established Article 3 standing sufficient to survive this even earlier stage of litigation. Heading number 2. Bragg is not entitled to a temporary restraining order. Legal standard, subheading A. In the Second Circuit, the same legal standard governs the issuance of preliminary injunctions and temporary restraining orders. To obtain either, Bragg must show 1. A likelihood of success on the merits, 2. A likelihood of irreparable injury, 3. The balance of hardships tips in his favor, and 4. That the public interest would not be disturbed by the issuance of an injunction. Like a preliminary injunction, a temporary restraining order is an extraordinary remedy never awarded as of right. Where a party seeking a temporary restraining order fails to establish a likelihood of success on the merits, there is no need to address the other prongs of the analysis. For the reasons outlined below, Bragg has not demonstrated a likelihood of success on the merits. The subpoena serves a valid legislative purpose and is not ultra vires or otherwise unconstitutional. That's subheading B. Congressional committees have constitutional authority to conduct investigations and issue subpoenas because each house has power to secure needed information in order to legislate. This power of inquiry, with process to enforce it, is an essential and appropriate auxiliary to the legislative function. That's a quotation from the U.S. Supreme Court case of McGrain versus Dougherty, 1927. The power of the Congress to conduct investigations is inherent in the legislative process. Watkins versus United States, Supreme Court, 1957. Of course, this power is not limitless. There is no congressional power to expose for the sake of exposure, nor may Congress issue subpoenas for the purposes of law enforcement, because that power is assigned to the executive and the judiciary. However, the Supreme Court has described the congressional power of inquiry as broad and indispensable. Indeed, without its investigative powers, Congress would be shooting in the dark, unable to legislate wisely or effectively. Congress may conduct inquiries into the administration of existing laws, studies of proposed laws, and particularly relevant here, surveys of defects in our social, economic, or political system for the purpose of enabling the Congress to remedy them. Importantly, a congressional subpoena is valid only if it is related to and in furtherance of a legitimate task of the Congress. The subpoena must serve a valid legislative purpose and concern a subject on which legislation could be had. The role of a court in evaluating a congressional subpoena is strictly limited to determining only whether the subpoena is plainly incompetent or irrelevant to any lawful purpose in the discharge of the committee's duties. Jordan and the committee have identified several valid legislative purposes underlying the subpoena. First, they reference the committee's interest in investigating the use of federal forfeiture funds in connection with the District Attorney of New York's investigation of President Trump. There can be no doubt that Congress may permissibly investigate the use of federal funds, particularly where the result of the investigation might prompt Congress to pass legislation changing how such funds are appropriated or may be spent. The District Attorney of New York has conceded that it used federal forfeiture funds in its investigations of President Trump. Defendants represent that the committee is considering legislation to prohibit the use of federal forfeiture funds to investigate a current or former president. This purpose standing alone is clearly sufficient to justify the subpoena and thereby to end this court's inquiry. On the record, at the hearing on the motion for emergency relief, Bragg's counsel conceded that the investigation of the District Attorney's New York use of federal funds is a valid legislative purpose. Second, defendants identify the possibility of legislative reforms to insulate current and former presidents from state prosecutions, such as by removing criminal actions filed against them from state to federal court. Congress, of course, has authority to consider and to investigate this potential legislative reform. And Congress also has authority to investigate legislative reforms to prevent local prosecutions that could potentially interfere with federal elections. Although Bragg speculates that any such legislation would be unconstitutional, that issue is for another day. The court will not, and indeed cannot, block congressional investigation into hypothetical future legislation based on Bragg's speculation that such legislation would not pass constitutional muster. Subheading C. The subpoena does not implicate the sovereign interests of New York. Bragg suggests that these are not the committee's true objectives. Indeed, he contends that the subpoena is actually intended to undermine and obstruct New York's criminal case against Mr. Trump and to retaliate against the district attorney. The court cannot passively accept this contention. The court is required to presume that a congressional committee's stated legislative object is the real object, citing again to the U.S. Supreme Court in McGrain. Moreover, even if Bragg's hypothesis about the committee's real motivations were correct, they are irrelevant. It is not a court's function to invalidate a congressional investigation that serves a legislative purpose. Indeed, the Supreme Court has instructed that so long as Congress acts in pursuit of its constitutional power, the judiciary lacks authority to intervene on the basis of the motives which spurred the exercise of that power. That's a quotation from Barenblatt versus United States, 1959. Whatever motives may underline the committee's subpoena, its inquiry may fairly be deemed within its province. That is sufficient to resolve this inquiry. There's a footnote here that I want to read. Bragg notes that there is no prior case in which Congress has attempted to subpoena a state prosecutor for the purpose of extracting information about an ongoing state prosecution. Defendants do not dispute this characterization or cite to any such case. However, there's also no prior case in which a former president of the United States has been criminally charged in a state court trial, in a state trial court, suggesting both parties swim in untested waters. Plaintiff next urges this court to apply the heightened standard of review outlined by the Supreme Court in Trump versus Mazars USA LLP. In Mazars, the Supreme Court outlined a four-part analysis relevant in assessing a subpoena directed at the president's personal information. Because congressional subpoenas for the president's personal information implicates weighty concerns for the separation of powers, the Supreme Court instructed courts considering such subpoenas to, 1, carefully assess whether the asserted legislative purpose warrants the significant step of involving the president and his papers. 2, insist on a subpoena no broader than reasonably necessary to support Congress's legislative objective. 3, be attentive to the nature of the evidence offered by Congress to establish that a subpoena advances a valid legislative purpose. And 4, be careful to assess the burdens imposed on the president by the subpoena. The Supreme Court did not, as Bragg suggests, indicate that the 4 Mazars factors apply whenever someone argues that a subpoena implicates significant separation of powers concerns. In any event, the same separation of powers concerns are not implicated here. The congressional subpoena in Mazars was directed at materials pertaining to the sitting president of the United States. In contrast, here the subpoena was issued to a private citizen who is no longer employed by any state government and who has written a book and spoken extensively about the subject matter of the inquiry, of the congressional inquiry. The court is not persuaded that Mazars applies to this case. Another footnote. Having discussed Mazars in his moving brief, Bragg seeks a second chance at arguing its applicability in his reply brief, contending that the case broadly governs subpoenas seeking a current or former president's information. That is clearly incorrect. In any event, the subpoena does not seek a current or former president's information. It seeks Pomerantz's information. Even assuming that Mazars were applicable, the court would reach the same conclusion. With respect to the first factor, Bragg does not demonstrate that the subpoena issued to Pomerantz, a private citizen, will occasion a constitutional confrontation. Congress has the power to compel individuals to testify. Indeed, courts have even compelled individuals actively employed by the executive branch who at least arguably hold executive privilege, and some of whom are attorneys obligated to protect privileged information, to appear for congressional depositions. Citing Meadows versus Pelosi, an opinion by the District of Columbia District Court, dismissing a challenge by a White House Chief of Staff Mark Meadows to a congressional subpoena requesting his appearance for a deposition, and citing another District of D.C. case, Committee on the Judiciary, U.S. House of Representatives versus Myers. as well as a third, Committee on Judiciary of U.S. House of Representatives versus McGahn. If those individuals could permissibly be deposed, the same is certainly true here. Second, the subpoena seeks only Pomerantz's testimony, not any documents or materials. Jordan specifically noted that many of the topics relevant to the committee's oversight were discussed voluntarily and extensively by Pomerantz in his book, as well as in several public interviews. The subpoena is not, as Bragg contends, an overbroad fishing expedition. Third, Bragg criticizes defendants' quote, flimsy evidence of a valid legislative purpose. But defendants provide evidence that the committee is investigating the use of federal forfeiture funds and considering the viability of legislation to protect former presidents from politically motivated state prosecutions. Bragg suggests this evidence is insufficient, but his conclusory assertions do not move the needle, whereas here, he has the burden of demonstrating entitlement to an extraordinary remedy. Bragg and Pomerantz insist that Pomerantz's testimony cannot advance any valid legislative purpose because, in essence, everything Pomerantz is prepared to say is already in his book. And he does not have any information about the District of New York's use of federal funds. Bragg and Pomerantz are not entitled to unilaterally narrow the universe of acceptable inquiry to the information and mental impressions that Pomerantz decided to sell in the pages of his book. If Pomerantz does not have any information about the District Attorney of New York's use of federal funds, he may say so if asked at his deposition. Finally, Bragg's suggestion that the subpoena would substantially burden both the New York criminal justice system itself and the district attorney's office is without merit. Pomerantz is a former prosecutor. He's not involved in the state prosecution in any way. Bragg provides no reason to conclude that the deposition of a former employee would interfere with the District of New York, the District Attorney of New York, or any of its ongoing prosecutions. The pending prosecution will move forward to the ordinary course, regardless of whether the committee deposes Pomerantz. Further, Pomerantz was not even employed with the District Attorney of New York at the time President Trump was indicted. Pomerantz admits as much. He has stated that the materials in his book would have no bearing on the litigation of the criminal prosecution of President Trump and would not prejudice any investigation or prosecution of Donald Trump. Moreover, Pomerantz emphasizes that he was not involved in the decision to bring the pending indictment against Mr. Trump. Bragg, therefore, does not satisfy his burden of demonstrating that the subpoena poses a threat to a state executive officer, a state judicial proceeding, or our federal system itself. The court is further unmoved by Bragg's purported concern at the prospect of injecting partisan passions into a forum where they do not belong. By bringing this action, Bragg is engaging in precisely the type of political theater he claims to fear. While the court need not decide the ultimate merits of Bragg's claims at this stage, serious constitutional infirmities are evident with respect to a lawsuit against defendants Jordan and the committee. The speech or debate clause states, quote, for any speech or debate in either house, senators and representatives shall not be questioned in any other place. Although the clause speaks only of speech or debate, it has been interpreted to protect all legislative acts. U.S. Supreme Court, Doe versus McMillan, 1973. The clause provides individual members of Congress and congressional committees broad immunity from civil suits, citing several U.S. Supreme Court cases. Because Jordan and the committee are likely immune, defendants contend that they are necessary parties who cannot be joined, and that under Federal Rule of Civil Procedure 19, the action cannot be maintained. Bragg disagrees. The court need not resolve this issue. Footnote. Despite pervasive discussion of the speech or debate clause in the relevant case law and governing authority, Bragg neglected to mention the clause whatsoever in his moving brief. However, Bragg seeks an opportunity to address this material issue, quotes, material issue, in his unauthorized reply brief. The court need not resolve this issue, but the distinct possibility of immunity weighs against concluding that Bragg has shown a likelihood of success on the merits. In all events, Bragg confirms in his reply brief that the court must consider whether there is a legitimate legislative purpose for the subpoena he seeks to quash. As explained above, Jordan and the committee have identified a legitimate legislative purpose, and accordingly, the court will not issue a temporary restraining order. End of part 2.